Judges in America are fighting back. They're doing it by criticizing the Supreme Court, their bosses, in oral arguments. They're doing it in anonymous interviews. They're doing it in opinions that they write. They're calling out the exploitation of the shadow docket by Donald Trump with the complicity of the United States Supreme Court, which results in orders that are not orders, opinions that are not opinions, precedent that is not precedent, except when the Supreme Court tries to shove it down our throat, providing no guidance to the federal appellate courts, the federal trial courts, nor explanation to the American people as to why whole provisions of the U.S. Constitution are being ignored or ripped out of the Constitution. We cover it all on the Legal AF podcast, and here's a clip.
Let's go to this issue, though, of when we talk about due process, though, playing out in the federal courts, what's pissing off, whether it's the Fourth Circuit or most federal judges around the country, is that, okay, well, now we are hearing the evidence. We're making rulings. We're finding things that the Trump regime is doing to be patently unlawful. We're the trial judge. We're the initial referee of this. But then it's like, if any of y'all watch football, it's like, we're the referee. We made the call. We don't even need to go. It's such an obvious call. We shouldn't have to go to instant replay. But every time we make a call, no matter what it is, it goes to instant replay. And then we get a call from New York. It's a very specific New York reference but you get a phone call and say, you've been overruled. Overruled? What are you talking about? You've been over. Every single time we're making the right calls each and every time. It's worse than that, though, because obviously the implications are people's lives. But the Supreme Court shouldn't even be getting involved in any of this stuff until there's a trial and until it goes through the normal Court of Appeal processes. The Supreme Court's using this emergency docket. And then they're not even doing briefings, like they're not even having oral arguments on a lot of these cases. Sure, for the case involving Trump's unlawful tariffs against the world, they're going to do oral arguments and they're going to hear it in like November. And it's still, these unlawful tariffs are going to at least remain in place until then. But mostly all these other cases, you get no actual discussion by the Supreme Court why they're ruling. They just say, hey, district court, we're staying or we're pausing your order until such time as it finds its way back up to the Supreme Court, which could be years from now, versus allowing the district court that's handling the case to administer orders. So, Popok, tell us about what we're seeing from judges across the country who are pissed.
It is extraordinary and unheard of. You and I, regardless of when we went to law school, we've never had a situation where there's been open warfare between an open hostility between district courts, appellate courts, and the United States Supreme Court. And now appellate courts and federal district courts have had it. And they're not only speaking anonymously like they did last week to NBC to express their displeasure and their open call for the Supreme Court to stop abusing them and stop letting them twist in the wind with unclear direction. But now, during a Fourth Circuit, which sits in Maryland, a Fourth Circuit oral argument, or it sits over Maryland and other places, the judges, a number of them, we're going to play one in a minute, decided to use part of the 80-minute oral argument to chastise the United States Supreme Court and tell them, if you think all we want from you is clear direction expressed in an opinion of a certain length, so we know what we're supposed to do, what the precedent is, and how to apply it. And instead, we are getting one paragraph, which has, or sometimes less, or a concurrence that we're supposed to glean like it's, magic 8-ball jurisprudence, shake the 8-ball. I think it's going to be a rough day for you today. That's what they're getting. And the judges now are saying it out loud. It was almost like a therapy session. But I'll play it in just 1 second. And what they're rebelling against, and what the American society is rebelling against, is that the Supreme Court is hell-bent to be complicit with Donald Trump, to allow him to exploit, with their approval, the shadow docket, which is a fast-track, short-circuited method of getting an appeal up to the Supreme Court, which is on an incomplete factual record, not properly yet developed below by the trial judge, on a incomplete set of briefs, legal written arguments, normally without even the help of amicus briefs or friends of the court briefs, no oral argument, almost rarely no oral argument. They only grant it rarely, without the deliberative process that goes into the United States Supreme Court in general to come out with one paragraph where they say it's not substance, it's just procedure. And they're using it to go after and destroy some of the most fundamental aspects of our United States Constitution, not just on the seams of the Constitution, the very fabric of the Constitution. Like one paragraph to destroy the Fourth Amendment, illegal search and seizure, and to allow racial profiling to happen again at the hands of Donald Trump's immigration shock troops chasing human beings through California and other states. I would have thought if they were going to put the Fourth Amendment out of its misery, they would have done it. They would have at least had the decency to do it in a full-blown appeal with a 50 or 100-page opinion with dissents and concurrences. No, it was one paragraph, and then 5 pages by Kavanaugh and a dozen pages by Sotomayor to tell me what just happened. I would have thought if they were going to take away the right that had been used for more than 75 years of federal judges to use temporary restraining orders on a national basis, nationwide injunctions to remedy constitutional violations, they would have done it in more than a paragraph or 2 paragraphs. And so federal judges below them, because there's 2 reasons you write an opinion. One is to teach down because they have to follow binding precedent in the hierarchy of our jurisprudence, lower court judges, the appellate judges, and the district court judges. But how can they possibly figure out what a 1 paragraph is supposed to mean, or if that's supposed to apply in other cases? Again, we're at the Oracle of Delphi moment where we don't know what, they just come out, make a pronouncement. I got to spend the rest of my lifetime trying to figure out what they just said. And the federal judges are getting frustrated. Let me play a clip from Judge Winan today, or earlier in the week, in an oral argument where it burst out into the open.
It's given us signals, and this so-called shadow document, that document that's being put out here, we can glean and probably predict pretty accurately. If that's our job, is to predict the Supreme Court and call that a win, I can tell you how we'll do it. We'll just do it the Supreme Court. You don't need this court. But you have to agree, as you answered Judge King's question, we have an independent obligation to consider the merits of this appeal. If it wanted to, it could have just told us, you don't need to do anything else. We're going to go ahead and decide it for you. So if it's decided the merits of the appeal, then it would have done that. It didn't do that. It didn't even tell us that. And that's the problem we got is we have a Supreme Court. I'm not criticizing the justice. I'm just saying you're using a vehicle that's there, but they're telling us nothing. And they're leaving the lower courts, circuit courts, the district courts out in limbo as to guess what they are doing or to glean or predict what they're doing, which may be correct to do. But the truth of the matter is they could easily just give us directions on it and we would follow it. When you don't give us clear directions, you end up with a situation where you're answering Judge Richardson's question. Well, they told us what to do. And then you answer Judge King's question, but I'm not saying they told us what to do. So that's a problem. So, we have an independent obligation. And that's what we ought to undertake here. And we do so independently. Even though some might want to predict, or even you could accurately predict what the Supreme Court, I don't think we should guess that. We have a job to do. That's our constitutional duty. The Supreme Court has its constitutional duty. We all should just do our job.
Do your job. We just had a week ago 2 judges on the D.C. federal. That was the entirety of the Fourth Circuit sitting in Richmond, Virginia, by the way. That was en banc. That was about a DOJ, Social Security case of great importance. And that broke out there. A week earlier, you've got 2 judges, Judge Millard and Judge Pan, who said to the Supreme Court about Rebecca Slaughter and her termination without cause from the Federal Trade Commission, which seems to violate on its face a 95-year-old precedent called Humphrey's Executor, literally say to the Supreme Court in writing, do your job. We're not going to do your job for you. We're going to apply a 95-year-old precedent that's on the books because you haven't told us otherwise. And so what did they do? 3 days later, they blocked that decision, signaling that they're going to overturn the 95-year-old precedent. But how is the court supposed to know that? And the other problem we have is they're not only not giving guidance to the judges and, of course, to the public, which can't understand, let alone legal AF figuring it out what it means to be able to have any legitimacy about their rulemaking, their decision making at the Supreme Court. That's why you issue opinions. I mean, I don't agree with the jurisprudence or the intellectual underpinnings, but at least I should understand them in order to debate it with you, so to speak. But then you have the next level, which is the Supreme Court getting prickly and attacking federal judges because they're not, quote unquote, following the one paragraph, or which is supposed to be on procedural grounds anyway. So you have, about a month ago, Gorsuch and Kavanaugh gang tackling a senior judge who was appointed by Ronald Reagan, William Young, up in Massachusetts, on a funding issue in which he ruled that the Trump administration couldn't cut off the funding on a certain program. And they said, "Oh, you didn't follow our precedent from the Department of Education." And he said, "What precedent? You mean the one paragraph on a procedural grounds where you told us it wasn't substantive?" I would never, they actually said, Gorsuch said that this was a judge that was defying the Supreme Court. See, this is bursting at the seams now. Supreme Court's getting prickly because they think they're getting defied, but they're not getting defied. They're just not giving clear direction to the federal judges below them. The fact that the entirety of the Fourth Circuit decided to use an oral argument. I kind of felt bad for the advocates there, because this was not about them. This was about a therapy session and them dropping a dime to call the Supreme Court and tell them how they felt. Now, the Fourth Circuit, just I'll leave it on this, has a particular hurt feelings because of all the 13 circuit courts that are in American federal circuit courts. They had the worst record at the United States Supreme Court on substantive appeals the last term. They were 0-9. They got overturned 9 times by the right-wing ideologues that occupy the United States Supreme Court majority. They won on a couple things that we like on Abrego Garcia, Judge Zinnis, and then the Fourth Circuit got affirmed 9-0 on another shadow docket. But on the real appeals, 0-9. So let's just say there was a lot of hurt feelings on the Fourth, so it was an appropriate place to do it. But last week, you got NBC doing an interview with 10 federal judges anonymously, obviously, because they're active judges, who said, "What are we supposed to do? We're not getting guidance. We don't know what to do off the shadow docket. You're not supporting us complaining about the Supreme Court. You're leaving us twisting in the wind. We're doing our job the way we did before Trump was president. And now suddenly we're at fault. We're defiant. We don't know what we're doing. We knew what we were doing for all the years until 9 months ago." And so, but I want to put this in last historical perspective for our audience. And I've only practiced law twice as long as you. Not even. You're catching up. So, but this has never happened. This is not normal. This has never happened where occasionally Supreme Court will be like, "Oh, I wish you had followed our rule." No. Open warfare between the two of them, where each one of them thinks the other one's wrong and is pointing the finger. No, we've never had that before. But that is the pressure testing that with Donald Trump is putting the rule of law and courts under as he continues to attack courts and judges. They're having their own existential moment. And we unfortunately are the victims of it, because they got to sort this out, because it's not helping America or our rule of law.
Here's what I think's happening. The Supreme Court gave Trump absolute immunity. Very different from the Brazil Supreme Court, which convicted Bolsonaro of insurrection and sentenced him to jail for 27 years. You actually have a functioning Supreme Court in Brazil, but our Supreme Court gave Donald Trump absolute immunity. I saw a nominee by Donald Trump for the Third Circuit Court of Appeals. Her name is Professor Mascott. She's a Catholic University professor, and she believes basically Donald Trump should get immunity for everything. That's why Trump's elevating her as a junior professor at Catholic University to become a Third Circuit Court of Appeal judge, for which she's absolutely not qualified. And during her testimony, she was asked by Senator Schiff, "Do you think Trump can send SEAL Team 6 to kill his political opponents tomorrow?" And she was like, "Well, I don't know. I mean, we'll have to, I did a whole video on it. It's ridiculous." But anyway, our Supreme Court gave him absolute immunity. He's taking that and breaking all of these laws. They don't want to expose They're weak. They want to avoid the right wing of the Supreme Court, which controls it. It's a 6-3 right wing Supreme Court. They want to avoid showing that the Supreme Court has no power, because what happens when Donald Trump then goes after them, like he goes after all of the other judges? What happens when he starts social media posting about them and saying, I'm not going to listen? The Supreme Court sees that as an existential threat, the right wing, to their existence, which they've already neutered their existence, but they see that they're worried about the public showing of that. So they issue these shadow docket rulings. They do it in a procedural way, so they're not actually creating precedent. And then they say, well, this will just work its way up in 3 courts. Then we'll decide and have oral argument. So what are they doing there? They figure in 3 years, 4 years, when these cases work its way back up to the Supreme Court, but at that point, the migrants will have been sent to concentration camps. The government will have been gutted. The economy will have been destroyed. But then in 3 years, this is their plan. It's obvious to me. Then they say, okay, it's time for oral argument. And then they issue all of these orders. And then now, if there is a Democratic president or someone else in charge other than Trump, but let's assume a Democratic president, then they go, whoa, executive branch, you can't do that. But wait a minute, you did the shadow docket for Trump. That was the shadow docket. We were being procedural. We weren't being, now we have to address the merits. And now we've seen the full merits. Oh, Democratic president, that's clearly an infringement on the separation of powers. Come back, watch this video in 3 years. That's what they're doing. It's obvious to me. They're not that smart. I could smoke them out from a mile away. What the hell they're doing. It's obvious. It's chicken shit.
Welcome back. We sit at the intersection of law and politics so that you don't have to, every Wednesday and Saturday at 8 p.m. Eastern Time on the Midas Touch Network, and a free version, commercial-free version, up on Legal AF Substack. Another good reason to go join us and help us to grow that pro-democracy channel as well. And then you're here on Legal AF YouTube channel. Take a minute and hit the free subscribe button and help us continue to grow our audience for Legal AF, the podcast. We're top 50 in audio. We're top 20 to 40 in video versions on YouTube rankings. That's all because of you. Help us to continue to grow that audience to keep us on the air. So until my next report, I'm Michael Popak. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.